The Honourable Clayton Mitchell.
Thank you, Mr. Chair, for indulging me. I do have a question for the Minister, and I saw him jump to his feet, and I was just hoping to get to him before he does answer, as I knew that he would. Mr. Chair, I did speak to it in my first reading with regards to a question to the Minister that I'm sure he will address in a moment. And the question is around what would happen in the event where an absent landlord or an overseas landlord that had a property that, one, wasn't in a position to be able to pay for that assessment to be done, or two, justified the ruling for that assessment to be implemented. I mean, there are a number of options. Obviously, if the assessment's not been done and the building may or may not be fit for purpose and may need to be removed or altered in some way, what happens with the cost of that? Does the assessment go ahead regardless and a hold is then put over that building using the Rating Act, or is it potentially demolished and just put red stickered and not to be used fit for purpose? Mr. Chair, there are some questions with regards to the notice requirements, and I think the notice requirements are very, very good, with the best endeavours of the agent to ensure that the neighbouring properties and tenants are aware that the building is undergoing assessment, obviously a seismic assessment. But it doesn't address the fact, once that assessment has been done, what requirements are of either the territorial authority or of the constable to ensure that the tenants are aware of the outcome of the assessment that has been undertaken. I mean, if it happened on a Friday afternoon, for example, and the assessment came through, it was given the green stamp, the rubber stamp of approval, but the council haven't had the opportunity to pass that on to the tenants. They may be still out in the community, staying on beds, couches, floors, or in hotel accommodation. And could it not be potentially put in there, or does he see that there'd be a requirement for that to actually be facilitated in there so that the tenants also get to see the outcome of those assessments as soon as practicably possible, as do the landlords and, of course, the neighbouring properties, which has been clearly articulated in this legislation. The new section 26A and 26B, which is with regards to the assessments of the structure, have been inserted into the Principal Act, which concerns the power to give direction by a controller or the constable, as I've just been speaking to, or any person acting under the authority of a controller to direct or order the owner or the owner's agent of a structure to arrange for an assessment of the effect of an event on that structure. And we at New Zealand First, during the cross-party meeting, have outlined that a criteria should be handed down by an overzealous worker, that we should have a criteria that would enable them to work that into it. And I see that that has been put in, and we're very pleased to see that there, Mr. Chair. We are supporting this through. We do support the supplementary order paper by David Parker going through the House, and if we could just have some clarity from the Minister, that would be muchly appreciated. Thank you.
The Honourable Jerry Brownlee.